I'm going to let you talk,
okay.
but then I'm not going to be interrupted. So go ahead. What else did you want to tell me?
I was I even have the proof on my phone because when I went on Google and I put in the court for 14A1 and 14A2 court, it says the address is 415 West Michigan Avenue. So that's where I showed up that day. I didn't know I needed bus fare to come to Washtenaw, and I didn't have it. And so I did call the court and I was put on Zoom. I was on hold, but nobody had, they told me that I waited 3 hours on Zoom. And at the end of that, and I have proof of that as well. I have proof of everything I'm saying, sir.
May I?
I was not, I don't think a bond was paid.
Billy Edmonds.
All right. I adjourned this out, so, well, that was well back then. I need a sticker. All right, where are we on this case?
Your Honor, I initially was going to countersue. I've been living with, I moved in August 25th, August of 25. And since day one, I've been dealing with cockroaches. Since October of 25, I've been dealing with bed bugs. I've went to the city, county, the public health department, code enforcement. I went to the news. I went to my landlord, everybody. I'm still getting bit to this day. It was so bad that I missed almost.
How come back to June you didn't file an answer with the court?
I went to 14A court on the wrong day and I missed the deadline. I am doing my best because the infestation caused me to miss almost 3 weeks of work. So I also know that when I have to countersue that I have to pay for that and I have to pay for like a jury trial and I didn't have the money at that time. Anyway, my lease is up August 1st. I'm not trying to stay there. I wish I didn't even have to stay there tonight. I'm just trying to get out as soon as possible, but I'm just need as much time just because the infestation has caused me to lose. I missed some work. I'm just started back working again and I get paid semi-monthly. So I also have to pay for like hazmat movers to clear out my apartment and everything. So I'm really just doing the best I can. And that's all I'm asking. I'm just asking also that this not be on my record because like I said, I have a lot of proof that I've been reaching out for help with this. And like I said, I'm still getting bit today. I really don't even want to stay there tonight, but I'm doing the best I can.
In order to establish setting aside a fault judgment, you have to establish two things. First of all, good cause for your failure to appear. Ma'am, if you say you went to the 14A2 court in Ypsilanti and you said you were held on Zoom for 3 hours and tried to appear on June 26th, we did not have somebody's in our Zoom for.
Yeah, I have the password and everything at home.
I'm going to let you talk,
okay.
But then I'm not going to be interrupted. So go ahead. What else did you want to tell me?
I even have the proof on my phone because when I went on Google and I put in the court for 14A1 and 14A2 court, it says the address is 415 West Michigan Avenue. So that's where I showed up that day. I didn't know I needed bus fare to come to Washtenaw and I didn't have it. And so I did call the court and I was put on Zoom. I was on hold, but nobody had, they told me that I waited 3 hours on Zoom. And at the end of that, and I have proof of that as well. At the end of that, they told me that I needed to contact the court. And that's when I came in, when I had the money available to file the paperwork that I needed to file. I have proof of everything I'm saying, sir.
May I?
I was not, I don't think a bond was paid to stay this.
No, I didn't pay $1,000 to escrow because I have been out of work because of the infestation and I get paid semi-monthly. So it's taken me a minute to catch up.
You done?
That's all I have to say, sir.
You have to establish good cause for failure to appear. I don't believe that good cause for failure to appear exist, I would also indicate that the judgment in this case was entered June 26th of 2026, that Friday. And we did not receive, nor was the motion on this signed off by the defendant until the 7th of July. Also, I had instructed the defendant, she's indicated on June 12th, she was going to get an attorney, she was going to file an answer. And I at that time reserved escrow. It would indicate that we did not receive a written answer, although she having given actually 2 weeks an adequate time to file it. It just wasn't filed in this case. And further, that even upon the filing of the motion, there shouldn't necessarily even be a hearing because she failed to post a bond for support. So for all of those reasons, the defendant's motion to set aside the judgment state the writ is denied. Thank you.
Thank you very much, Your Honor. Have a good weekend.
You do the same.
I have a question.
Yes, ma'am.
So the next step will be a writ, correct?
Should the plaintiff so choose, the step will be a writ.
Thank you.
Pines of Clover Lane versus Keontae James.
Good afternoon, Your Honor. Brent Singer, plaintiff.
Not checked in.
Not checked in? Like take a default?
Yeah,
Solemnly swear, did I swear? Do you solemnly swear a firm testimony you're about to give will be truth?
I do.
Nothing but the truth, so help God.
I do.
Go ahead, sir.
Right now, it looks like the rate paying in this case is $3,413.33. There is cost owed of $175 for a redemptive total of $3,588.33. This would have a writ date in 10 days. Did I do a proposed order?
Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested with due intent.
That's for me. Thanks, Judge. Have a
Thank
good
you,
weekend.
sir. Have a great one. Huron Vista versus Moesha Harrison.
Hey, please, the Honorable Court, Steve Gann, P 78219 for the plaintiff.
Okay. Your name?
Moesha Harrison.
All right, what is the amount that's owed?
Currently, Your Honor, there is $4,460 in rent, 4460 in rent, 240.81 in court fees, for a total of 4700.81.
All right. We did receive a note that the client was informed that she needed to reduce her balance to $3,000. She's working, what it says is working with other agencies to help her reduce the balance down to 3,000. All right.
I was in contact with SOS. I'm sorry.
No, go ahead.
I was in SOS contacted me yesterday to see how much shared initiative is going to pay. I was in the rental office this morning with Michelle and Damon from Shared Initiative. He gave her a verbal response of a promise to pay the $2,000, and I emailed my caseworker with SOS to let her know like he's willing to pay $2,000. He said he can have it submitted by Monday, and then after he get his payment submitted, then SOS can proceed with it. Can proceed with their payment.
All right.
But that one, the 2,000 will knock it down under 3,000.
But we don't have a written confirmation.
No, he's been working. He did tell me that I can offer the attorney his number to get some type of, or even you, his number to give some type of written confirmation of the promise to pay with the 2,000.
All right. You need to tell him he needs to send a written confirmation to the attorney, but at this point, in this case, without that written confirmation, and this being the third hearing, I'm going to find that there's no tribal issue after a hearing. I'm going to grant a judgment for possession, total redemption amount of the $4,700.81. I'm going to extend the writ or move out date to July 31st, 2026. Okay. So here's what that means. You need to tell them that you begin to get in jeopardy at the end of the month.
Okay.
So if they're going to get the 2,000 in, they need to get it to the landlord And then Hawk needs to work really hard, get a commitment letter or something to the landlord
Okay,
so that they can show that this balance is paid before we click into August and a new balance arises.
okay,
Okay?
okay.
If I may, Your Honor, I will add to the judgment, if she gets this paid, with the court's permission, I'd be willing to, and her request, set this aside and dismiss the case if it's paid in full.
All right. Got that?
Yep,
Okay. Thank you.
thank you.
Thank you, Your Honor.
Thank you. Lakestone Apartments versus Marjorie Marshall.
May it please the Honorable Court, Steve Gann for the plaintiff.
Thank you. Hello. Your name?
Marjorie Marsh.
Okay. We have an indication that Friends Indeed, they had made an approval. We're gonna, let's see what exactly it says. There was a referral made to Friends Indeed. Friends Indeed caseworker to approve case by the end of the day on 7/16. Or 7/16, so yesterday. Have you heard from Friends Indeed, ma'am?
Have not. And I tried to be in contact with them, but I think that they said they were going to pay $3,000.
That they were gonna pay 3,000? Okay, how much is owing?
Your Honor, the exact amount of rent is 3,000. There's also 252.80 in court fees for a total of 3252.80. She did make a payment, or somebody made a payment on her behalf on the 13th of 1491.11, bringing it down to 3,000 plus costs.
Got it. Okay, so what,
At the court course. You know,
pardon?
I didn't know there was court.
Yeah, I'm not, they'll have to be paid. I'm not so much worried about that. I'll be honest with you, because of what it looks like is that you, what it looks like is somebody got you paid you the 3,000, so that now Friends Indeed or whoever can take over and get the rest of it paid.
Yes.
Got it? That's what it looks like. Maybe a little short, but if we get there, we'll find a way to try to solve the 200. Okay.
Okay.
Well, so what I'm gonna do is I'm gonna adjourn this out 1 week to the 24th, 2026 at 12 noon. And ma'am, I get in touch. Were you working through Hawk or just through Friends Indeed?
So I think I worked through Hawk, and I talked to someone named Autumn, and she put me in touch with like Friends Indeed, and I went to Friends Indeed like 3 times and gave them everything they requested.
And so somebody else other than Friends Indeed paid the other part,
Yeah. So a church.
and Friends Indeed
Yeah.
gonna look to do that. So we're gonna give them a shot to do that.
Okay.
Okay.
Yeah, the church paid.
Pardon?
A church paid the
Got it. Okay, so
help me.
church paid that, and now you're down to that level. So now we gotta wait for Friends Indeed to work.
And then I'll be able to pay all this and be on the right track.
Okay, we'll get you there.
If I
All
may,
right.
if I may add, Your Honor, ma'am, if you could
Yes, sir.
if you could speak to your manager on Monday, if you guys can come up with agreement on the court costs, we can do what's called a conditional dismissal, get that to the court. The court would need that in their hands before Wednesday, because the clerk needs to set the schedule for Friday. So if you want to work on Monday with the manager and reach out to me, maybe we can get this resolved and keep you from having to come back to court next week.
Okay. So I just asked the landlord to excuse the the court costs.
Yeah,
No,
to work something out, or that it would be paid somehow later.
Okay then.
Okay? All right.
Okay, do I need to come back on, you said the 24th?
On the 24th, I'll need you back,
Okay.
unless
Okay.
that's at 12 noon.
Okay, thank you.
All right? You have a blessed weekend.
Thank you as well. Thank you.
Thank you, Your Honor.
Thank you. Lakestone versus Gwendolyn Munson. I think I'm just gonna adjourn it out to next week, July 24th, 2026 at 2 p.m.
And Your
And
Honor, I would just also indicate, being that this is brought under the just cause statute, I believe the rent is current at present. It is. Whether the court wants to enter and order a escrow order requiring ongoing rent, should it proceed to a jury trial, and I will be very clear, Your Honor, If frivolous
I
claims
will.
are filed, I will be seeking sanctions. Additionally, Your Honor, I'd ask for actual attorney's fees in this. And we would be filing a motion for summary disposition based on all the things stated on the record here today. So I'd ask for the escrow order in the event it goes into August, but I'll defer to Your Honor.
Right. I will indeed order escrow. I think I might be one date premature. So if it happens next week, I would certainly issue an escrow order.
Thank you,
Right.
Your Honor.
Thank you.
Thank you, Your Honor. And as a
Thank you.
brief aside, Your Honor, I don't know if you know, but you're quite famous on YouTube. I do enjoy watching you on YouTube when I get home from work.
You might be now too. This one
If
might
you're
get
watching-
the
There's no,
interest of.
I don't see any sovereign citizens here today, so I think we're gonna dodge any recording of us.
If you're watching me when you go home, you need a hobby. All right.
It is my hobby, Your Honor.
Thank you, sir.
Have a good
Scio
day.
Farm versus, thank you too. Aline Seguski? Say it again? Stankiewicz. Okay. I was staring at it. I knew I was going to blow it up. And Nassim.
My son is at work.
All right. How much do we have owing?
With costs, Your Honor, $4,850.56. Your Honor, I did have an opportunity to speak with Ms. Stankiewicz via email. She had reached out, as Your Honor had suggested, to see about a payment arrangement. Unfortunately, Scio Farms is agreeable to extending it to the 31st of July, but they aren't agreeable to going further beyond that.
Yeah, Your Honor, I actually do my onboarding for a job today after this hearing, and I start on Monday, and I will be able to catch up. I did get the email from Ms. Dornbush, didn't get to speak with her, and they agreed on the 31st. I set it up so I can make 6 payments by the 31st and have it paid off in full. So Monday, Wednesday, Friday, I wasn't able to make a payment today.
Okay, gotcha.
I haven't gotten any of my checks from unemployment yet, but hopefully soon. So I can set it up to 6 different payments. So it'll be paid off by the 31st.
31st of July.
Correct. And that's what she said Scio agreed upon.
Here's what I'll do. I'll grant a judgment for possession, finding no tribal issue after a hearing in this case for the total amount of $48,60.56. And I'll extend the redemption date to July 31st, 2026.
Thank you, Your Honor.
You're welcome. Have a great weekend. Scio Farms versus Arkeem Kirk. Arkeem Kirk.
He's on Zoom, Your Honor. but-
Yes, sir. Yes, sir. I'm right here.
Okay, there you are. All right. Okay, how much is owing?
With costs, Your Honor, $1,612.73.
Mr. Kirk, you told me you'd have the balance paid by
Yes, sir.
yesterday.
Yes, sir. Yes, sir. I'm just waiting on my check. I'm just waiting on my check to hit. As soon as it hit, I will have it paid, sir.
Okay. So when is your check supposed to be due?
It should have hit yesterday, but I know it will hit by Monday or Tuesday, sir.
Okay, so here's what I'm gonna do. I'll find no tribal issue after a hearing. I'm gonna grant a judgment for possession with the redemption amount of the $16,1273. Is that right? With a writ to issue in 10 days. So you got 10 days to get that paid.
Yes,
So-
sir. Thank you, sir. Yes,
Paid by
sir.
the 27th. All right, okay, take care.
Yes,
Have a
sir.
good
Thank you.
weekend.
You too. Have
Put
a
a mask
blessing.
on.
Yes, sir.
Put a mask on or go inside.
Yes, yes, sir. I will.
All right, take care.
Yes, sir. Thank you.
Scio Farms versus Jessica Jones. And Shaman Jones.
Your Honor, I don't believe either defendant is present today. They had both reached out to indicate that they were both unable to appear for work, for having to be at work. I did, though, speak with Jessica Jones, and I let her know that even if she wasn't present today, that I would be agreeable to extending the writ date out to the 31st. They had requested a longer term payment plan that my client wasn't able to accommodate, but my client was willing to go to the 31st. So if the court wants to enter this as a default judgment, I would just extend it to the 31st.
Judgment to the plaintiff by default. What is the total amount?
Total redemptive amount, Your Honor, is $2,046.51.
Okay. We'll enter judgment in that amount with that redemption amount with the writ to issue the 31st. Sile Farms versus Christina Franklin. Christina Franklin? Not checked in. You may proceed.
Thank you, Your Honor. There is rent to retain of $2,111.63. Costs are $192 for a total due of $2,303.63. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, in the amount requested, writ to issue in 10 days. Sile Farms versus Antoine Bailey. Really? Antoine Bailey. No response. You may proceed.
Thank you, Your Honor. There is rent to retain of $2,011.92. Costs are $192 for a total due of $2,203.92. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, in the amount requested, writ to issue in 10 days. Sile Farms versus Melanie Clemens. Oh. I'm sorry, what'd you say? Yeah, she is. Melanie
Hello?
Clemens?
Here.
Oh, there she is. Okay. There was a referral to Friends Indeed, isn't it?
Yep.
To Friends Indeed for
Yes.
her. Okay, did you get the $1,100 paid?
No, because Friends of Deed is paying the whole bill. I pick up the check Monday.
You do?
Yep.
Okay.
Yeah, I was supposed to get it today, but the person had a family emergency, so I pick it up Monday.
All right. I'm because of that, and she had filed, I think she had filed her paperwork on that. I'm going to give her the adjournment to the 24th, 2026 at 2 p.m. Okay? Once
And
you
Your
get
Honor-
that check, get it over to the landlord.
And
Yes.
then I don't even have to show up, right?
Nope, but you got to make sure everything's paid.
Right, it will be. Okay.
If I may ask though, Your Honor, just so we're sure that it's covering everything, I don't want Ms. Clemens to get the check and then find out that there's a shortfall. Ms. Clemens, we've got you at $2183.92. Is that what Friends Indeed is cutting the check for?
Yes.
Okay, perfect.
Okay. All right, Ms. Clemens. Thank you.
Thank you. Have a good weekend.
You too. Sile Farms, this is Adam Bryant.
Your Honor,
Good afternoon, sir. Your name?
Adam Bryant.
All right. And what is plaintiff's claim?
Your Honor, Mr. Bryant made a $400 payment today, so that should bring him down to $769.70.
Got it. So there was a one payment that he made, and then he made another four, which is, okay, that's about right. All right. When are we gonna get this balanced?
I'll have it paid off by the 31st. I'll make a payment next Friday, the 24th. Bare minimum of $400, and then the remainder we paid off on the 31st.
Okay, so you're sure you can get it paid by?
Absolutely.
All right, what I'll do is no tribal issue after hearing judgment for possession. I'll enter in judgment in the amount of $769.70, was it?
Yes.
Yes.
I'll extend the redemption date to July 31st, 2026. All right.
Paid, I don't have to show up on the 31st.
Pardon?
As long as everything's paid, I don't have to show up on the 31st.
You don't have to, well, you don't have to show up again. All right.
Thank you so much. Have a great weekend.
You do the same. Spice Tree versus Jaquavius Carroll.
Hi, Aaron.
Hello, Carol. All right, what is plaintiff's claim?
With costs, Your Honor, we've got Mr. Carroll at $1,928.34.
I
Carol,
paid
did you,
I paid
go ahead.
1,000. I paid 1,000 on Wednesday.
I'm not sure when my ledger's from, Your Honor. I don't know if there's a date on here. We've got a $700 payment on the first, which I think probably was accounted for. Your Honor, if we can pass on the matter briefly, I can verify, or depending on what Mr. Carroll says about the remainder,
Right, that's what I was thinking. Mr. Carroll, when can
Yes.
you get the remainder of this paid?
I get paid again.
Are you driving right now?
I'm pulling over to the side. I'm at work, and I couldn't get off. So yeah, I'm pulling over now.
Well, let me know when you're stopped.
Okay, I'm stopped now. So I will be able to pay. So I have this thing at my job where they let me do daily pay. So I will be able to pay another 400 next. I'm gonna say this upcoming Friday, and then I'll pay the remaining balance on the. Sorry, I just have to check my calculator. And then I'll get paid again on the 29th, and then I'll pay the remaining balance. So I talked to the leasing
So by
officer.
the end of the month, you can have everything paid?
Yes, everything will be paid for sure.
So what I'm going to do is find no tribal issue after hearing, judgment for possession. I'll enter it for the total amount. I'll let you credit whatever he has paid in. So I'm going to enter it for the 1928.34. I'll extend his writ date to July 31st, 2026.
Okay.
All right.
Thank you, Your
Thank
Honor.
you, sir.
Okay, bye.
Sylvan Crossing versus Grant Wolf. Grant Wolf, not here. You may proceed.
Your Honor, Mr. Wolf made a payment through the online portal today. The issue is I'm trying to clarify with my client if it's a payment that has already cleared or not. So if we could adjourn this for 1 week, once I get the clarification, I'll submit a dismissal.
July 24th, 2026 at 2 p.m. And then Valley Ranch versus Stephen Shelton. Oh, there he is. All right. What do we have owing?
Your Honor, the amount I have is $4,434, but let me double check and make sure that my client, looks like they paid $1,400 in a cashier's check, so that's gonna bring his balance down to, if I'm doing my math correctly, $4,034, nope, 3,000. Oh, I'm not even gonna do the math, Your Honor, I give up. 4434 minus, this is easy math, I should be able to do this. I don't know why I'm not able to. $3,034, Your Honor.
All right. And sir, when are you going to get that paid?
I should have it all paid off before the 31st. I'll make another payment this coming week. So probably like Wednesday or Thursday, I'll make another payment of $1,000 and get the remaining paid before the 31st. So I should.
All right. So here's what I'll do. Since you made that payment, is I'm going to grant a judgment for possession, finding no tribal issue after hearing for the 3034. Was there change on that, counsel?
No, actually, Your Honor, it evened out.
Okay. For that amount, I'll extend your writ date to July 31st. So get everything paid by then. You'll be all set, young man.
Okay. Thank you. I appreciate it.
Thank you. Have a good weekend.
You too. Bye.
And I think, Ms. Dornbush, I think that's it.
I would concur, Your Honor. Thank you.
Have a good one.
Thank you. You as well. Have a great weekend and stay safe out there. As you are telling everybody, wear a mask, Judge. Wear a mask.
That's it. That's it. It's
Indeed.
nothing to play with. All right.
No,
Thanks.
it's nasty out there.
All right. Thank you. All right, what are we doing?
Your Honor, the prosecutor and I have reached an agreement. We submitted the paperwork and I would like to move for immediate sentencing if there's no objection. I don't think there is. It's possible.
Do I have paperwork? I have no paperwork.
Okay. We did sign the plea agreement and we sent it back to the prosecutor. I'm not sure if I was supposed to file that or.
I apologize. My understanding was that it was filed with the court by the defense attorney.
Oh. So they thought you.
I could have. I'll just double check right here. Just give me 1 second. Good morning. I sent it to Miranda Dover. Yeah. Are you Miranda Dover? The prosecutor's Dover, right?
Yes.
Yes. Okay. I only sent it to the prosecutor, so I did not send it to the court.
Okay. So I didn't get it, which I knew about 5 minutes. All right. So I have to adjourn it out because I got to have paperwork.
I will file it.
Well, thank you.
We'll take the next hearing available.
As you are, the defendant is
In custody. Yes, they're gonna have to writ, and I don't have the 2 weeks out necessary for a writ, so I will adjourn it to August 6th, 2020, 9 a.m. or as your invite indicates, bond will continue. All right. Thank you. Thank you, Ms. McCormick.
Thank you.
Court calls case, People versus Patrick Lay.
Michael Vincent on behalf of Patrick Lay.
Your name, sir?
Patrick Lay.
Mr. Vincent? Happy birthday.
Been pretty happy so far.
Huh?
Been pretty happy.
Has it? Fantastic. Guess my staff let me know, but we got you nothing.
84.
84?
Yeah.
God bless you.
I did my workout this morning.
It worked. So did I. I got coffee. All right. All right. What are we doing on this?
We have a restitution that we agreed to $1,685 some cents. We were here last time and nobody knew who was going to take the check. We have the money lined up through your folks up in Tawas, right? The folks are up in Tawas. They're ready to send a check. We don't know to who.
Okay. And the court can't be involved in that. So do you guys need an adjournment to sort all that out? Or?
I'm standing in for APA to on this matter in Sacramento. And so we would like
An adjournment. All right. I'll put it over. This matter, probable cause conference to August 6th.
Today, my client be excused for showing up. And if they just give me the address or somebody to send it to, as much as I love coming in here,
I mean,
it's my favorite thing.
Gonna try to like get it the own birthday present. Is there going to be an idea that this case might go away? Is that, maybe. I don't need an answer.
I'll come.
That isn't, and
I'll be here.
And I will excuse your client from.
All right. Thank you.
Thank you. Because I like seeing him. It's Vincent. That bothers me.
Your second favorite thing, right?
All right. Thank you. Thank you. Okay. Bond will continue. Court calls case People versus Patrick White.
Afternoon, Your Honor. Dan Garrett on behalf of Patrick White.
Your name, sir?
Patrick White.
Thank you.
Your Honor, I'm asking for an exam date. I believe discovery is complete.
People have their witnesses available the 28th.
Your Honor.
All right. Set preliminary examination, July 28th, 2026 at
9 a.m. Judge Freshour.
9 a.m. before Judge Freshour.
Thanks, Your Honor.
All right, thank you. Bond continue.
Thank you, Your Honor.
Thank you.
Court calls the case of the people versus Zachary. Is that Halhowski?
Correct.
Deeply honored.
And Your Honor, Joe Simon on behalf of Mr. Halhowski. Mr. Halhowski, state your name, please.
Zachary David Halhowski.
Thank you.
Your Honor, I've been corresponding with Ms. Dover right up to this moment, actually, and we're requesting an adjournment of the PCC to determine the ability of the case to proceed.
All right. Well, August 6th work for you, sir.
Yes, Your Honor.
August 6th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Why did Simon's thank you not sound so received?
Because I'm still celebrating Mr. Vincent's birthday in my heart.
Okay. Oh, that explains it. Court calls the case. People versus Dominic Brewer.
Alberto, on behalf of Mr. Brewer, who is approaching the podium and will be standing to my right. Mr. Brewer, please state your name for the record.
Dominic Brewer. Thank you.
Your Honor, today is the date and time set for probable cause conference. We are still working on discovery. We're asking for an adjournment.
August 6th, 2026. No.
Thank you, Judge.
All right, thank you. Bond continued. Court calls the case. People versus Kwame Edwards.
And on behalf of the people, Your Honor.
Edward Lucas on behalf of Kwame Edwards, who is approaching, Your Honor. Yeah, I think we are close to a resolution. Prior to setting it for an exam, I'd ask for an adjournment. We can push it.
All right, would you be able to get it? Are you close enough that if I set it for the 28th in the morning, you'll have it? Or that's a Tuesday? Or
I was looking to avoid that Tuesday date, the 28th. If we could do after that.
Why is he avoiding date?
We have an evidentiary hearing at 9 and it may go most of the day.
August 6th.
Thank you, Your Honor.
August 6th. Thank you, sir.
All right. Thank you.
Fine. Court calls the case of versus Gerald. Is it Marhausen?
Bring the door.
Good afternoon, Your Honor. Deanna Kelly appearing on behalf of Mr. Marhoffer, who's approaching. Your Honor, would just read.
Gerald Marhausen. All right, go ahead.
Your Honor, we're requesting just a short adjournment. I substituted in for the public defender. We're requesting discovery. I know they've already taken steps, the public defender's office, to forward it, but I don't have it yet. So like a short adjournment.
I can do the 28th or August 6th.
It will, okay. August, which date?
6th.
That works great, August 6th.
The 6th.
Thank
All right.
you.
August 6th, 2026, 9 a.m. or as your invite indicates.
Wonderful. Thank you very much. Nice to see you.
Thank you. Court calls the case of the people versus Jeremiah Meese.
Ashley, help us with the people.
I'm here.
Good afternoon, Your Honor. Robert Ellman with and on behalf of Mr. Meese. Mr. Meese, please state your name.
Jeremiah Meese.
I need you have a camera, Mr. Meese?
Yes, sir.
All right, thank you. All right, what are we doing?
Your Honor, today we'll be waiving exam. There's been an offer from the people for Mr. Meese to plead under HIDA, and he'd like to take advantage of that at circuit court.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing? You'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right?
You do raise your right, Your Honor. I will note for the record, defendant is of the age where the people do not have to consent to HIDA.
Got it. Preliminary examination having been waived, defendants bound over to circuit court on the single count. Mr. Elm.
Thank you, Your Honor. We would waive any formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
September 14th at 1:30 with Judge Hamud.
September 14th, 2026, 1:30, Judge Hamud.
May I have just one moment, please?
Yes, you may.
Thank you, Your Honor. There was a co-defendant on this matter. I was just verifying that person was also in front of Judge Hamud because I think the court knows how that could happen.
Yes.
What was the date?
September 14th.
Thank you, Your Honor.
Bond will continue. All right. Thank you.
Thank you, Your Honor. Very good to see you.
Good to see you, sir.
Can I approach, Your Honor?
Yes. Court does call the case People versus Rayshawn Dawson. Two cases.
Good afternoon, Your Honor. James Fifelsky appearing on behalf of Mr. Dawson on the case ending in 5307.
Good afternoon, Your Honor. I'm Zoe Hutchins, Assistant Public Defender, also appearing on behalf of Rayshawn Dawson in case ending in 0645.
All right.
As you can see, Mr. Dawson is not here. I've checked the hallway at least 3 times, and I know co-counsel has been checking as well. I have not heard from him personally. I would just ask the court to issue a show cause.
Yeah, that's happened. Bench warrant will issue for defendant's failure to appear. Bonds will be set in the amount of $10,000 cash surety on both cases.
Your Honor, the defendant also has a community corrections violation for not reporting for testing.
I didn't see that.
It just came through this morning.
Got it. Okay, so it's bound to, I got it.
And is that on both?
$25,000 cash surety.
Is that for each file? Because I didn't see a bond violation on the 5307.
It's gonna matter. The bond, this particular bond violation was just on 0645.
Okay. Thank you.
Thank you, Your Honor.
Court calls the cases of the People versus Freddie Anderson.
She told us for the people.
Deborah Geraldine Bledsoe Ford on behalf of Freddie Anderson.
And oh no, you're fine, sir. And Assistant Public Defender Natalie Pate with on behalf of Mr. Anderson in the case ending in 1055. Mr. Anderson, say your name for the court.
Freddie Anderson.
All right. What are we doing?
I'd like to join with the defender and her plan. My client instructed me what her plan was. It's an adjournment, I believe, to get him treatment.
So, Your Honor, yes, I was going to be requesting an adjournment possibly of 2 weeks. Mr. Anderson had provided me the information today that I need in order to submit a referral for the recovery court here in Washtenaw County, so that hopefully he can be screened for that.
Gaddy, Assistant Public Defender on behalf of Mr. Boyd.
Sir, if you can unmute and state your name, please.
Maurice Deshaun Boyd.
Thank you.
I just need to fill it out. Your Honor, I'm asking for an adjournment so I can discuss this matter further with the people, and also we're trying to look for any potential recovery court out county, outside of Washtenaw County.
Adjourn the matter to August 13th, 2026, 9 a.m. Bond continue.
Thank you. I'll bring a green sheet for the second.
Court calls case People versus Nicholas Coops.
Actually, don't thank you.
Assistant Public Defender Davi Lee on behalf of Mr. Coots. Mr. Coots, can you tell the judge your name, please?
Nicholas Coots. Thank you.
And I'll be requesting adjournment in order to review the offer of relief received from the prosecutor. Here I will be submitting a green sheet. I did receive the offer a few moments ago.
Okay. Adjourn it to July 28th, 2026.
Sorry, Your Honor. My offer involves the defendant getting into a recovery court in the county. So I'm going to ask if we have a little bit more time than that.
Got it.
6, maybe even 13.
All right.
The defendant had previously had failure to appear some bond issues, so
All right. This is the only thing holding him, but he hasn't appeared, correct?
Yes, Your Honor, so I'd be requesting a short adjournment so that if Mr. Coos does not want to pursue that, we are not adjourned for that to happen.
August 6th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Austin Berg.
Lucas on behalf of Mr. Bird. If you could please state your name.
Austin Bird.
What are we doing?
We're looking to adjourn for continued negotiation.
Will be adjourned to August 13th, 2026, 9 a.m.
Your Honor.
Court calls case People versus Misty Davis.
Morning, Your Honor. Assistant Public Defender Emzo Hutchins on behalf of Mr. Davis to move the approach. State your records. Misty Davis.
All right, what are we doing?
Your Honor, we'd like to set the phone for exam, please.
Discovery is complete.
Yes.
And would the people have their witnesses available the 28th? Preliminary examination will be set July 28th, 2026, 9 a.m. before 12 noon before me. Thank you. Court does call the case of the People versus Maisha Gaines.
Morning, Senior Assistant Public Defender. James coming from lockup.
I don't think so. Oh, she is, yes. Okay.
Maisha Gaines.
I have a plea form in front of me that she's gonna be pleading to the charge of operating with a high BAC, the 180 offense. Upon that successful guilty plea to that charge, count one would be dismissed. Defendant is also agreeing to plead guilty as charged in case 25S 460 SD. That's the court's full understanding of the agreement.
That's correct. That is correct, Your Honor.
All right, may I have her sworn?
Solemnly swear to affirm the testimony about the oath, nothing but the truth, help God.
Yes, I do.
Name, please.
Maisha Gaines.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating with a high BAC. That is a misdemeanor punishable by a jail sentence of up to 180 days, a $200 to $700 fine plus court costs. The court should order rehabilitative services and any community service the court deems necessary. Could also order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge. And you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form or had one signed on your behalf?
Yes.
You have any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Absolutely.
And because you believe that you are indeed guilty of this offense?
Yes.
On the date of,
Yes.
do you know what you had and how much you recall?
Vodka.
All right. Were you stopped by the police or was there an accident?
Stopped by the police.
You know why they stopped you?
No, yes,
Pardon?
yes,
Why'd they stop you?
swerving, I guess.
Okay. And you're not challenging the right of the police to stop you in this?
No,
All right. Were you ultimately arrested?
yes,
Were you taken to the hospital for a blood draw?
yes.
And what were the results of that blood draw?
Your Honor, I believe it was 0.326.
0.326?
I believe that's correct.
Right. Do you have any reason to dispute those results, ma'am?
No.
Ma'am, I do have to inform you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, thank you, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and reporting screening is ordered at 1482 probation. Sentencing city, August 12, 2026, 10 a.m. before Judge Barr. Bond will continue.
Your Honor, may we address bond
You
briefly?
may.
At this time, Ms. Gaines' bond does not have a bond. However, since the time that she previously missed court, she has taken care of all of her outstanding warrants, which includes a matter out of Wayne County, for which she's serving a sentence as she is taking care of these cases. Anticipate will have completed that sentence in August. We're asking at this time for a nominal bond.
Any response?
Or if you were encouraged to let students that she is at the history of chapter, I am you are sex or behavior by being out of extreme interest. That is the only one I was seeing.
At this point, given the rather high blood alcohol content involved in this case, I know it was a while back, but given that and given the nature of the charge, I'm going to deny your request to change your bond. I'll leave that up to the court after it gets an assessment. All right.
All right.
Thank you. Court does call the case People versus Tommy Lee Clark.
Good morning, Your Honor. Annabelle for Mr. Clark, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Permission to practice is granted.
Thank you. Please state your name.
Tommy Clark. Thank you.
All right, Your Honor, we would like to adjourn in this case. We have some motions we'd like to file.
What?
There are some motions we'd like to file.
How soon are you going to file the motions?
2-week adjournment should be sufficient, Your Honor.
Probably going to need more time than that. I mean, you guys are going to file them. I need a response.
Okay.
What are the nature of the motions?
Motions to suppress evidence.
I'll adjourn the probable cause conference to August 6, 2026. I'll schedule any motions we get in after that point in time. All right, August 6th.
Thank you.
Bond continues. Go green sheet. Thank you. Court does call the case of People versus Zachariah Haruska Dennis.
Request.
Just like that other guy, Michigan, Michigan, Michigan. Permission to practice is granted.
Good morning, Your Honor. Ashley Hannibal for Mr. Huska Dennis.
Dennis. Thank you. What are we doing?
We're requesting an adjournment in this case as well, for plea negotiation purposes.
We had other matters before me. We set those out. I don't know what.
I don't have that in front of me. Okay, prosecution is saying it's the 6th.
When? Fifth. That would have been my only adjournment date I had, so
Yes, sir.
the 5th. Okay, then I will adjourn these the 6th.
All right, thank you.
Thank you. Court does call the case of the people versus Deborah Collette.
Good morning, Your Honor. Nick Darnell, requesting permission of practice pursuant to Michigan Court Rule 8.120 in of Assistant Prosecuting Attorney. Actually,
Remind me, where are you from?
was like where I'm from.
That's not a hard question.
Novi, Yorkville area.
Okay. Where are you in law school? Remind me. Where?
University of Iowa.
I didn't know that. Did I? No, because I would have made jokes about corns and pigs and things. I did that? Did I? I forgot he was from Iowa. Okay, I'll remember. How will I do that? Because he's as tall as corn. All right. And rest of the practice is granted.
And I have public defendant on behalf of Ms. Collette, who is present via Zoom. Ms. Collette, can you please state your name for the record? Okay, I can see her speaking.
My name is Deborah Joanne Collette. Can you hear me? Thank you.
Yes, Ms. Collette, thank you. Your Honor, we are requesting an adjournment. We have successfully gotten in contact with the 25th District Court Sobriety Court and are working on getting her screened there. So we are asking for an adjournment.
Do you have timing on the screening at all?
I got the information to them on Monday, so I would.
August 13th, 2026.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Court calls the case people versus Huffman. Iowa, really? Iowa.
Nick Darnell for the people, Your Honor.
Hold it. Is he in law school in Iowa?
Yes, Your Honor.
They have one?
Yeah, it's a pretty cool thing.
I don't think so. All right, we'll see. You guys got it.
Oh, that's right. I'm sorry. When the music stops, we'll both grab a chair.
All right. Your name, sir?
Orby Huffman.
Thank you. What are we doing?
Your Honor, this is a case signed to us. We have a with Mr. Huffman. He does not want our office to represent him. He has spoken with Bishop Moore from our office, who he indicates that he is going to retain, but I don't think he's spoken any.
Okay, so you're going to retain counsel, sir?
No, I haven't misunderstood what he meant. If he's my attorney, that's fine.
Pardon?
Then I
Oh, you guys, so never mind.
yeah, I'd ask the court to pen matter. Maybe I can go back and talk to him.
I'm sorry, I didn't understand.
No, it's okay. It's all right. I just want to make sure we're getting everything so we can take him back. Court does call the case people versus Wilnisha Crosby.
Actually, call this for the people.
Assistant Public Defender Davi Lieba on behalf of Ms. Crosby.
Hi, Your Honor, Wilnisha Crosby.
Hello. All right. What are we doing?
And Your Honor, we're still discussing the potential offer. In this case, I'd be asking for an adjournment.
August 13th, 2026, 9 a.m. On continue.
Thank you, Your Honor.
Thank you.
Court calls. You're welcome. Court calls the case people versus Scott Matthews.
We're going to go over to the people, Your Honor.
Our Assistant Public Defender Natalie Pate for Mr. Matthews should be approaching soon. And
Iowa? Do you know anybody from Iowa?
Well, Your Honor, I actually lived in Iowa for a little while when I was in junior high. So it's great.
That explains a lot.
Mr. Matthews, can you please take the name for the court?
My name is Scott David Matthews.
Thank you, Your Honor. I have had the opportunity to meet Mr. Matthews and go over both police reports, and we do for sure have media in one case. The other case, we might have gotten it since I've spoken to Ms. Dober, but it was on its way to our office very shortly, the media in the other case. That being said, I'm requesting an adjournment so I can review that video with Mr. Matthews. And also because Mr. Matthews does have several pending misdemeanors in the 15th District Court, and I've been talking with the public defender who represents him there, and we're hoping to potentially reach some sort of global resolution of everything. But of course,
Do we know when those?
he was just seen a couple days ago for his first pre-trials, but I do know that there was still some discovery outstanding on some of the misdemeanors at that time.
Okay.
I would ask for maybe like a 3-ish adjournment.
3-ish weeks. It's an Iowa thing. August 6, 2026, 9 a.m.
Thank you, Your Honor.
Right. Thank you, sir. Thank you. Court calls case People versus Rashawn Ellis. I did not know. I didn't know.
Good morning, Your Honor. Public Defender Nazi Carey, I can really, on behalf of Mr. Rashawn Ellis, who is approaching. Okay. Judge, we ask that this matter be set for preliminary examination, and we'd also like to address it.
Out.
Correct, Your Honor.
Okay, I can solve that. All right. Discovery is complete then?
For knowledge, yes.
People have their witnesses available the 28th?
We'll try, Your Honor. Thank you.
Preliminary examination will be set in person, July 28th, 2026 at
9 a.m. with Judge Fresh.
9 a.m. before fresh hour.
Your Honor, in regards to bond, Mr. Ellis is currently on a tether.
Yes.
The home confinement tether, Judge. This particular case had been dismissed at preliminary exam a few months back. The people were unable to proceed at that time. And he is currently on probation in circuit court. He's been doing well on his probation, compliant with everything. They did not have a tether on him. When this case was reauthorized, he was picked up on the warrant, unbeknownst to him, at the time of his arrest. When he was arraigned, a tether was subsequently placed back on him. We're asking that the tether moved. Rashawn has a number of things that he's doing, helping his family, helping his mother, and he has been compliant without a tether on his circuit court probation, and it's just this reauthorized case that has reactivated the tether issue.
There is a bond information form that was prepared in this case. I don't know if the court's had a chance to review that. I will, for the record, highlight that we requested the capture surety bond plus the GPS center of home confinement because the defendant is on felony probation, was found in possession of an assault style rifle pistol with a 40-round magazine, 20 live 5.56 rounds of ammunition. The police report also contained Instagram selfies where the defendant was posing with this assault rifle, flashing gang signs and a ski mask.
And Judge, as bad as it sounds, I completely understand. I think that the issue is that whatever the tether is doing, he was doing just fine without it. After this case was dismissed.
Well, I guess I'm unclear timing wise. So does this case, the allegations in this case arise while he's on probation?
I believe so, Your Honor.
That was the original probation. He has been violated for his probation in the circuit court matter. He is back compliant.
Right, but when as of, what was it, March 15th, 2026, was he on probation?
Yes.
Okay, so the allegations in this case regarding the weapons occurred while he was on probation.
That is correct, Your Honor.
Okay. Anything else?
I just want to reiterate that this case was originally brought It was sent to preliminary examination.
Right, I get that, but the case can come back.
It can, absolutely.
It's coming back. And the one fact that hasn't changed is that the allegations in this case occurred while he was on probation.
Correct.
Okay. Motion for bond modification. All right. Bond will continue with the tether and this is. Thank you.
What happens when dozens of tenants stand before the same judge, all hoping for one more chance to keep a roof over their heads? This courtroom session wasn't about violent crimes or dramatic confrontations. It was about something millions of families fear: losing their home. Throughout the hearing, one case after another came before the judge. Some tenants had found new jobs. Others were waiting for unemployment benefits, rental assistance, or their next paycheck. Nearly every person promised the same thing: just give me a little more time. Instead of treating every case the same, the judge listened carefully to each person's situation. One tenant had finally landed a new job and laid out a detailed plan to pay the entire balance by the end of the month. Another had already made several payments and simply needed a few more days for another paycheck to arrive. In case after case, the judge balanced the landlord's legal rights with the tenant's effort to catch up, often extending redemption deadlines while making it clear that those deadlines had to be taken seriously. But some of the hearing's most emotional moments involved people receiving help from community organizations. One woman explained that a local charity had agreed to pay her entire overdue rent, but a family emergency delayed the paperwork by just a few days. Rather than forcing an immediate eviction, the judge granted another short adjournment so the payment could go through. Another tenant described living with a severe cockroach and bedbug infestation for months. She told the court she had missed weeks of work, struggled to save money, and simply wanted enough time to move out safely without carrying the infestation into her next home. The judge listened carefully before explaining why the legal requirements still mattered, even when the circumstances were difficult. Perhaps the most moving case involved an elderly tenant whose situation had drawn the attention of Adult Protective Services. A caseworker explained that missed rent wasn't caused by bad intentions, but by declining mental capacity and a breakdown in the support systems that were supposed to help him. Agencies were now working together to restore his housing assistance and secure funding to prevent an eviction. Hearing that, the judge encouraged everyone involved to move quickly so the tenant would have a real chance to remain in his home. By the end of the session, one message stood out above everything else. The judge wasn't simply signing eviction orders. He repeatedly searched for practical solutions whenever tenants showed they were making genuine efforts to pay, work with assistance programs, or resolve their housing problems. But he also reminded everyone that deadlines matter and promises must be followed by action. For many families, those extra few days could make the difference between keeping their home or losing it. What do you think? Did the judge strike the right balance between enforcing the law and giving struggling tenants another chance? Let us know in the comments below. And if you enjoy real courtroom stories and powerful legal moments, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss another courtroom case.